I'm Steve Murphy, and welcome to the Insider Exclusive. Today we go inside the world of the Federal Employers Liability Act and how Don Britt of the Crow Law Firm taught Union Pacific Railroad a $48 million lesson in corporate responsibility. Stay tuned. I'm very pleased to have with us today the two lawyers that made all of this happen. Don Britt, welcome to the show.
Nice to be here, Steve.
John Gilbert.
Nice to be here,
You're
Steve.
both with the Crow Law Firm.
That's correct.
Yes.
Tell us what happened with Eric Doy.
Well, Eric was an employee of the Union Pacific Railroad, and he had gone to work for them in 2005. He is a resident and grew up in Southern California, and he was hired in what is known as the signal department.
He's actually out in the field all the time.
Yes.
He was a member of a construction gang, and as a member of a construction gang, he was assigned along with his fellow gang members to work in various locations throughout the southwestern United States.
Right, anywhere where Union Pacific has tracks, basically, right?
In the Southwest.
There'd be special projects. For example, in the time frame in which his accident took place, which was July of 2007, the gang was working north of Tucson, Arizona.
And on the day of his accident, he flew from Los Angeles.
Yes, he flew from
to Arizona. Right?
Yes, he did, and he was picked up at the airport by one of his fellow employees, a gentleman by the name of Robert Torres, and Mr. Torres was driving one of the Union Pacific company trucks that was assigned to the construction gang that Mr. Doy was a member of.
Right, and I think this is real important here. We're going to get to that a little bit later. He picked him up in a company truck, right?
That's correct.
And he was driving him to a company assignment, correct?
Well, they were assigned to stay at a particular motel in Tucson. Again, they call it corporate lodging. During the trial of this case, it was clearly established by the foreman of the gang, Mr. Ibarra, that the employees had full authority to use the company vehicles for whatever purpose they deemed necessary.
I understand that from the motel, he was on assignment going out to the job location, correct?
No, actually, the sequence of events on the day of the accident is that Eric flew to Tucson, and Mr. Torres took the company truck and picked him up at the airport. The ultimate destination was back at the hotel. Torres had already checked into the hotel, and he then, because all of the members of the gang had keys to the truck, he then used the truck to pick Eric up at the airport. The uncontradicted testimony at the trial was that the members of the gang had the authority to use the truck. So Mr. Torres picked up Mr. Doy, and then they went and stopped on their way to the motel at a Walmart to purchase certain things that were necessary for them to complete their work. In this case, one of the key elements that we focused on was a drink called Pedialyte, which most people associate with children and giving it to children who had diarrhea. Actually, the purpose of it is to rehydrate the child. It doesn't correct the problem.
Is it kind of like Gatorade?
It's exactly like Gatorade. It's an electrolyte replacement fluid, and because of the working conditions, and this was very important in this case, the men worked under extreme heat. The testimony was it could be 110 degrees plus. The work was very difficult. They sweated profusely, and they needed electrolyte replacement in order to work safely.
Right. I understand that the company provided that in some cases, didn't they, on the job site, right?
Not at this location.
But at some job sites they did provide that.
That's correct. They did.
Yeah. So they were actually getting something that they needed anyway that sometimes the company provided, right?
That's right.
So they purchased this drink and other things that they needed.
Yes.
They're on their way to the job site?
They're going back to the motel to check in.
Going back to the motel. What happened then?
Well, at that point, they were on a frontage road running parallel to the interstate highway that they were going to take back into the city of Tucson. And Mr. Doy was the passenger. He was the only other occupant of the vehicle. Mr. Torres was the driver. Mr. Torres became distracted, took his hand off the wheel. The vehicle, which was a Ford 550 commercial pickup truck.
Big utility truck.
Big utility truck. It drifted off the road. The right wheels got onto the soft shoulder. It was later demonstrated through our accident reconstructionist that Torres was going approximately 20-25 miles over the 40-45 mile an hour speed limit. And rather than control the vehicle to a slowed stop, did what a lot of people would do in emergency. He cranked the steering wheel back to the left, lost control. The vehicle went into a violent swerve, crossed the highway, went up an embankment, through a fence, turned around, and ended up rolling in what we would call the slow lane of the interstate. And during that roll, Mr. Doy's neck was fractured.
What happened as a result of this accident? The truck overturned.
Yes.
Eric's neck was broken.
Yes.
And it was broken exactly where? Because I understand there can be varying degrees of severe injury to the neck.
Eric was deemed to be a C4-5 quadriplegic, so
Right.
the break was actually in the C4-5
In the
area of his neck.
Yeah, in the photos,
cervical spine.
In the photos we show the rescue squad actually they cut the roof off the truck, didn't they?
They had to cut
take
the
him
roof
out of the
off.
truck?
Yes, they had to cut the roof off to extract him from the vehicle.
Mm-hmm. Wow. And as a result of this, what happened to Eric?
Well, Eric is, the medical diagnosis is that he is a C4 quadriplegic. And what it means practically, he has no feeling from his nipple line down or movement. He has no bowel or bladder control. He has no use of his fingers. His fingers are bent, as I'm trying to demonstrate to you here.
Virtually no fine motor skills in his fingers.
Mm-hmm.
He has some gross function of his arms. So in one of his wheelchairs, his manual wheelchair, he can push using some special gloves. He can push
Right.
on the wheels.
Right now we're going to go and show some of the scenes where we show him in the hospital. Let's go to that right now.
Okay.
Nolly to be cleared, Nolly 1102B.
So we can see that for the rest of his life, he has severe medical problems here. Now, a case like this, and this is why we're doing this story at all, is it's pretty clear to both you and most everybody who's watching this show that if somebody's on the job, they're driving in a company truck, they went to pick up something that was needed for the workplace, right? That it's a company disaster. I mean, it's something that the company should be responsible for, but that wasn't Union Pacific Railroad's response, was it?
No, it wasn't. And what we should point out at this point is that the railroad industry is unique from certain other industries in that neither the railroad nor the employees are governed by state workers' compensation laws.
They're governed by what?
It's called the Federal Employers Liability Act. It was a congressional enactment first passed in 1908. And it holds that the railroad can only be held responsible for an injury if the railroad was negligent or violated certain safety statutes.
Right.
It's a situation where, unlike workers' compensation, we have to prove fault. We also have to demonstrate that the employee at the time of the event was in the course and scope of their employment.
Those are very important words, aren't they? In the course and scope of employment, because Union Pacific said that these guys were not in the course and scope of their employment, right? They're out screwing around someplace.
They said that Eric was commuting that day. He was commuting from Los Angeles to Arizona, and therefore that was one of the basis of their defenses. And the other defense, they said, was that they're going to the Walmart to purchase whatever they purchased was a personal errand, and therefore they said that they were not in the course and scope. Legally, it is not necessary under the federal law that a person be on the job being paid by the hour, as they are in this case. What needs to be shown is that the activity is incidental to the employment, that it confers a benefit on the employer and the employee. And that is why in this case, for example, we brought in medical and scientific testimony to talk about the health hazards associated with excessive sweating in the work environment where they were, and this is why they needed the Pedialyte.
Yeah.
Matter of fact, Eric told us he really hated Pedialyte and hated to drink it.
Right. See, I've only drank Gatorade, but there is such a thing called Pedialyte?
Yeah, and it's not something that we would probably pick up at the store.
Right.
But
it serves the same purpose.
it does. And what's interesting is that Mr. Torres is the one who introduced Mr. Doy to the Pedialyte because he was a marathon runner and did a lot of running. And through that, he had come to the conclusion that Pedialyte was a better electrolyte replacement substance than Gatorade. It's really kind of a matter of personal choice, but these two gentlemen preferred the Pedialyte.
You know, it's interesting you bring up the scope and in the course and the scope of employment. I remember another reading of another case where a stockbroker was driving home after work, talking to a client on the phone, smashed his car up, killed somebody, whatever. And then the person, you know, the victim's family, their lawyer sued the investment company because he was in the scope in the course of his employment by talking on the phone to his client, which was a client of the investment firm. This is the same kind of situation. My question to you is, you know, we deal with a lot of stories where corporate America denies any responsibility, and they know they have the firepower, the legal firepower, to starve off, if you will, you know, victims, people who are helpless, like Eric Doy. What were some of the tricks, if you will, that the law firm that represented Union Pacific tried to derail, if you will, the success of your lawsuit?
You know, I guess I'm hesitant to use the word tricks, although I'm not unsympathetic to.
Well, I'm a layman. I can use that word.
It's okay. It seemed to us that the strategy of the defense was to delay this matter as much as possible and make it as difficult as possible for Mr. Doi. He's a resident of Southern California, and we filed our lawsuit in the Eastern District of Los Angeles, which is the city of Pomona.
Where he lives.
Where he lives.
Yeah.
And he hired out here, and the Union Pacific does business in the state of California. And their first gambit was to ask the court to dismiss the case, saying that California did not have jurisdiction to hear this matter.
Meaning, I'll interpret that, so they could move it some other place, make it difficult for him to travel there, right?
Sure, they wanted it back in Tucson.
Mm-hmm. And here he is a quadriplegic. It's kind of difficult to get to Tucson as a quadriplegic.
With all of his medical care, except for his initial stay at the hospital in Tucson, all of his medical care was by his home in the general.
Yeah, and he has to be cared for daily, doesn't he? You know, all day long with a caretaker.
24/7.
Because he virtually can't do anything himself, correct?
No, he cannot. So anyway, that was the first thing, and actually the court, alternatively, they asked the case to move to Placer County which is near Sacramento, which is the railroad's principal place of business designated principal place of business in the state of California.
And let me ask you, do they have a lot of railroad workers living in that county?
In Placer County?
Yeah.
They do, but not nearly the number in Los Angeles County.
Okay.
But the court, what the court did was proper. The court actually granted, first of all, the court kept the case in California but transferred it to Placer County. Once it got to Placer County, we then made a motion to change venue back to Pomona. This sounds like a very intricate and strange way, but procedurally we couldn't ask the court to consider the convenience of Mr. Doi until jurisdiction was fully vested in the state of California. Once that happened, the court in Placer County immediately moved us back to Pomona. We then asked the court to accelerate the time frame and give the case priority because of the severe medical problems Mr. Doi was having, and over the objection of the Union Pacific, who the court granted our motion. Now what they also did to make it difficult is there is by contract a benefit, disability benefit, that is called an off-track an agreement. And all that's required to be paid this money is that you be in a company vehicle with authorization. Clearly he was. Clearly the uncontradicted testimony trial was true. Yet they denied him that benefit. That was separate from the lawsuit and was not.
The reasoning was?
He was commuting. And so they just chose not to pay him the money. And we didn't have the jurisdiction to go after that particular matter. That's a matter of contract between his union and him. But every step of the way we encountered difficulty. Their actions made it more difficult to get the full cooperation of the health care insurer. We had, and I let John talk about this, John spent almost every day for months and months just trying to get Eric health care.
We're going to bring in a moment here what's an expert called a forensic economist who's going to determine how the award was awarded, and I want you to tell us what the verdict was here in a minute. But they're going to explain how you arrive at that. Ultimately, you won at the trial level, didn't you?
Yes.
And you won a huge amount. In fact, I think it's the largest verdict, right, in the history of FILA. Is that correct?
It is.
48 million? Was it 48 million?
It was a little over. The verdict was a little over 48 million, with some credits that I won't get into now. But the verdict, the judgment was entered was about 48 million and about 11,000 and so forth. And and one of the reasons that it is, quote, the largest is because of the enormity of the loss. I recently was conferencing with lawyers who represent railroad workers all over the United States, and the truth of the matter is none of us recall a person so afflicted as Eric, a quadriplegic, ever having a jury decide his case against a railroad. So no one had, although there are very few quadriplegic cases tried, just in general. Actually, no one, that to my knowledge, knows of any cases tried against a railroad under these circumstances.
Well, you know, my hat's off to you because he deserves every penny. There's no price.
Absolutely.
There's no price for, you know, what has happened to him. I am going to bring in now Dr. Barry Benzion, who
Yes.
is your forensic accountant, forensic economist,
Economist, yes.
who was able to show the jury why such an award should be awarded. I'm very pleased to have with us today a forensic economist. His name is Dr. Barry Benzion. Welcome to the show.
Thank you.
Your responsibility in this case was primarily to determine the economic losses to Eric Doy for this horrible accident that happened to him. Explain how you go about doing that.
Well, there are two major economic losses. The first one we refer to as the loss of earning capacity, his ability to work and earn money that he had prior to the injury has been taken away by the injury itself. So our job in that case is to determine how much he could have earned had he not been injured for the remainder of his life, working for the railroad as a signalman that he was.
And if I remember correctly, the year that, and correct me if I'm wrong here, Don, but the year that he was, the last year that he worked, he had an earnings of, I think, $60,000.
No, a little more than that.
A little more than that.
Yes.
So we have a chart, which is a loss earnings chart. And that's one of the things you project. You project like how much would he have made considering how old he is. At the time of the accident, he was 30 or 28?
29.
29. And if he had worked another 40 years and if he had been promoted as a normal person, correct?
We didn't actually compute it for 40 years. We assumed that he would have stopped working when he could have retired from the railroad at age 60.
Okay.
So we had basically a 31-year projection for his earning that was divided between
Right.
past loss up to the date of the trial, a year and a quarter or so, and the remainder being in the future.
Right. Now, Don, explain, there's two types of losses here, aren't there? There's the economic loss
Yes, the
and a
economic-
non-economic loss. What's the difference?
Well, economic is what you might call direct out-of-pocket expenses. The loss of a paycheck, the necessity to pay for medical care, things that we call hard dollar losses. In our practice as lawyers, we call those special damages.
Mm-hmm.
Separate from that are non-economic losses, which is the pain, the suffering, the loss of enjoyment of life. And that is completely separate and is in the sole discretion of the jury as to what's appropriate given the evidence.
And out of the $48 million, I understand the majority was non-economic losses, wasn't it?
That is true, although
Okay.
the economic losses were very substantial.
Getting back to the economic losses, you look at what is his loss of earning power. What are some of the other things you look at?
The second more, and in this case, the more expensive part, is what we call the cost of his life care plan. The cost that it will take to take care of him, to provide all of his equipment, his wheelchair, his hospital beds, as well, in this case, the amount of money you will have to spend on an attendant care,
Yes.
because, as you know, quadriplegics require substantial amount of care, human care by
Yes.
others. They have to be turned over, they have to
Yes.
be fed, they have to be clothed, they have to receive assistance in a variety of activities that you and I do automatically and a quadriplegic cannot do without help.
Great. Well, listen, I want to thank you very much for coming today and explaining that to our audience, because a lot of people are really unaware, you know, what these things really cost. And thank you for doing a good job. One of the things that come out of a tragedy are people that are inspirations to others. And today, we're fortunate enough to have with us Daniel BRITT. Welcome to the show.
Thank you.
You're a tennis player.
Yes, that's right.
You were moved by this whole case, weren't you?
Yes, sir, I was.
And what was your relationship, your tennis team's relationship with Eric? What happened there?
He provided our team with inspiration and the willpower to make it all the way to state. He gave us the motivation in matches where we felt we were getting down on ourselves. You know, we'd think in our minds, you know, how would Eric feel in this situation, or how grateful would he be if he were able to be out here and play with us. And instead of letting our anger take control of us in the match, we would think of Eric and, you know, and realize how fortunate we are to even be playing a tennis match. And that just by itself, you know, led us all the way to state with that mindset.
Did he ever say anything, you know, to inspire you guys to go win the championship?
Well, at the time, it was in the midst of the trial.
Yes.
And my dad, he was constantly telling us and updating us with how the trial was going.
Right.
And how Eric was under so much pressure, although he continued to overcome it and eventually succeeded in the end.
Well, I'm glad that Eric inspired you guys, and I know that just being associated with your team, Eric is just a lot better person and feels grateful too. And I want to thank you very much for doing what you're doing, and keep up the good work.
Thank you.
This is an inspirational story and a great victory for your client. What's the status of the case now?
Well, the Union Pacific has filed an appeal with the district court that covers the trial court in Los Angeles County.
And they're appealing for what reason?
Well, in our opinion, to simply delay the inevitable.
Sure. But I mean, when they file the appeal, they state reasons why they're appealing. What are those reasons?
We haven't reached the point where they have set forth their reasons. However,
In other words, they just file a notice of appeal.
Correct.
You haven't seen their brief or anything.
no, but we think we have seen their legal arguments, and it's going to be a rehash of everything we've seen from day one.
You've done a remarkable job, and I'm glad you came here today so the world can see this. How can folks get a hold of you? What's your website and your telephone number?
Well, we have a website. It's crowlaw.com. We also have an 800 number for the Sacramento office, which is 800-795-6555. And in Southern California?
800-499-9904.
Well, thank you for being great lawyers, and thank you for being on the show, John.
Thank you, Steve.
Thank you, Don. Thank you for watching. You can get more information about our guest and the issues at insiderexclusive.tv. Come back again.